Good afternoon, everyone. My name is Leanne Wyville, and today I'm representing Impact Innovation Group, working with the Queensland Government to bring you a webinar series for Queensland Small Business Week. Today, our webinar presenter is Cathryn Warburton from Acacia Law. I'll be introducing her shortly, but just while we're waiting for everybody to arrive, I'm going to go through some of the tools that we have with the Citrix GoToWebinar system for those people who haven't been involved with our webinars before. So your screen should look something like this. You'll have the slides and you'll have your own control panel right here, usually on the right-hand side. So just make sure that you have that opened up, and a good way to make sure that it always stays there is to click on View and uncheck Auto Hide. And if you do need to let go of the program at any time, remember to collapse it first with this little button here, and then you can expand it again later. We have some interactive tools that we're going to be using today. One you'll see is called Raise Your Hand, and on the left-hand side of your control panel you should see a little hand icon. Now, if you have located that, could you please click the button to put your hand up so I can see if you have located the hand icon? Lots of hands coming up there. Yes, thank you very much. That also means that the audio is working. That's good to see. Okay, also we have the type in the questions box. What we're going to do today is put the questions and answers at the end of the presentation. That makes things smoother, and then we know we have plenty of time to answer lots of individual questions. But as those questions occur to you, just pop them in this box, which is called Questions. It's also in your control panel. And type those in, and we will call those out at the end of the presentation. And today, Cathryn's going to run a poll, so keep an eye out for the poll section, and when it's time to do the poll, have a look for poll in your control panel, and we'll be able to let you know the results of that poll. Also, what you can do, and I recommend that you do that now, you can do it at any time throughout the webinar, but it's best if you try and do that now so that you don't forget, is that we do have some handouts in this section as well. We have a copy of the slides of Cathryn's presentation, which she's kindly agreed to share, and also there's a list of some other webinars that are happening this week that you may be interested in. So look for the handout section and click on the downloads and get those now while you can. Alrighty, so I'm going to be introducing Cathryn now. Just to give you some background on Cathryn, Cathryn Warburton is the legal lioness. Overcoming severe bullying as a child instilled in her a passion to protect others. As a skilled litigator, she indulges in her dream to push back against business bullies who target her clients. She's an international award-winning lawyer and patent attorney and 4-time published author. Cathryn bulletproofs her clients' businesses and protects them like a mama lioness protecting her cubs. She makes sure that no business is left without access to affordable, easy-to-understand legal information, and she does this through her books, proactive legal workshops, and one-to-one legal services. So now I'm going to hand over the screen to Cathryn, and she'll take it from there.
Thank you very much, Leanne, for that very kind introduction. And as Leanne said, my clients call me the legal lioness, and I'm the founder of a law firm and patent attorney firm called Acacia Law. Now, today we are talking about intellectual property in small business. So if you were expecting another topic, you're not in the right place. But if you're expecting intellectual property, that's what we're talking about today. Now, before I start, just a couple of general expectations. You're welcome to type in your questions at any time. And if you have questions that you prefer not to share with the group, I am available afterwards for those. But please understand that what I'm telling you today is general information and not specific legal advice. So different situations might differ, and you might need different advice depending on your specific information, your specific situation. Also, generally, when I talk about IP, I talk for several hours at a time. IP is intellectual property. So I might say IP and I might say intellectual property. In my workshops, I take several hours to cover IP. So today I'm going to be giving you a condensed version, a very broad brush version. So if you want more details on any specific point, please go ahead and ask those questions in the question box. So the topics that we're going to cover today really is a broad overview of what is intellectual property, and more importantly, why should I care? And I'm going to do this by way of client examples. All of the examples that I'm giving you today are actually real-life client examples that I've had permission to share with you. And the reason I love to share real-life examples is because my great passion is to help businesses avoid making the same mistakes over and over. So by sharing client examples, I can help you hopefully avoid some of those potential pitfalls. I do talk briefly about intellectual property ownership because that's one of the main areas in which people have problems. There will be hopefully time for questions, and once we've done all of that, if there is time, I will also run through a particular type of business so that we can apply what you've learned to that particular type of business. So sometimes people say to me, you know, I don't know, a business coach. So would I really have IP in my business? And at the end of the session, we can go through that particular example if there's time, depending on questions. So I wanted to first thank you for your time and attention today and start off with a poll. Leanne, have you got that poll going, please? And the poll really is the question about, does your business own IP? Yes, no, or I don't know. So I think the poll is going at the moment. So if you can start it, yes, lots of people are answering. Fantastic. That's wonderful. Thank you so much for your interaction. We've got 55% saying yes, their business does own IP, 32% saying no, and 14% saying they don't know. Don't know is going up to 17%. So yeah, it's exactly 50% saying yes, your business does own IP, and 50% either saying no or they don't know. So that's fantastic, and thank you for your interaction. Now, I just want to show you a slide. Well, I think we might have to close the poll. This is a statistic from the Australian Bureau of Statistics, which says that 76% of small businesses have no intellectual property protection. And I know half of you either didn't think you had IP or knew that you didn't, or you weren't sure. But out of the rest of you, it's interesting to note that 76% of small businesses have no IP protection. And my view is, and hopefully by the end of the session you'll agree with me, my view is that every single business owns some type of intellectual property. And so it's really important for you to understand the different types of intellectual property, how you can protect them, and to make sure that you don't infringe somebody else's intellectual property. And I love this slide. This is actually really why I run workshops and why I do webinars, because when you know a little bit about intellectual property, you can avoid falling into that big gaping hole in the middle. So hopefully by the end of it, you'll all understand that you do actually own intellectual property in your businesses. And there is a difference between having intellectual property and protecting intellectual property, and you'll understand that as we go along. So often I have people come to my workshops and they say, well, why should I care about IP? I'm a small business, I don't think I have IP, or I don't think it's important enough. And there's several really important reasons. One of the important reasons is to make sure that you're not infringing somebody else's intellectual property. And I will provide you with some examples as we go along. But this is one place where small businesses often make a mistake, or they don't realize that they could be infringing somebody else's intellectual property. And I've had clients frequently crying in my office because they didn't understand, they didn't realize that they inadvertently infringed somebody else's IP. And I've even had clients go bankrupt. So it's a very serious thing, or it can be very serious. The second point is to make sure that you own and protect any IP created within your business. And because half of you weren't sure if you had IP or you didn't think you had IP, if you fall into that category, this is a really important point for you. Every business creates intellectual property as you go along, and so you need to be aware of it and make sure you protect it. One of the ways you can protect it is by making sure that you own the intellectual property. So if you've got somebody who you've got on board who's creating something for you, it might be as simple as a social media manager. If they're creating posts for you, you need to have an agreement with them as to who's going to own the copyright in those social media posts, for example. The third reason to care about intellectual property is so that you can leverage off it. And I know a lot of small businesses have an ideal and a goal to become franchisers, to franchise their business. If you don't have a trademark registered to start with, you can't effectively franchise your business. Also, later on, when you're thinking of selling your business or getting investors in, if you don't have your intellectual property sorted out, it's difficult to get those investors in. So, and Apple does this very well, even with just their brand name. I have a teenage son, and he will buy an MP3 player, even the older version, that's got the same software as a no-name brand MP3 player. He'll rather buy an iPod and spend hundreds more dollars. He'll spend hours earning that money, but he'll buy the name. So it does help you to leverage your business and make smart use of your IP. And then finally, of course, the other benefit of having your IP sorted out is to make sure that you don't get somebody else infringing your intellectual property. So the three most common and costly mistakes that small business owners make is failing to protect intellectual property, inadvertent infringement of somebody else's intellectual property, and then ownership disputes, which is an area in which small businesses often get bogged down in. So now we're going to move on to the different types of intellectual property and some real-life examples for you. So firstly, what is IP? And you can see there's a whole lot of different types, and I'm going to go through them individually with examples. So we have patents and innovation patents, trademarks, registered designs, copyright, trade secrets. Freedom to operate is not really a type of intellectual property, but it's a search, a kind of search that you do to make sure you don't infringe somebody else. And then franchises, again, it's related to intellectual property. It's not an intellectual property in itself. And then I throw in IP and social media because social media is a place where a lot of people can make intellectual property mistakes. So firstly, patents and innovation patents. Quite simply, a patent is a registered right. You register through the government department, and the patent protects the way that something works. Your invention or innovation has to be new to get a patent protection, and your protection lasts up to 20 years if it's a proper patent or a standard patent, and for innovation patents, it lasts up to 8 years. And so when you file your patent at the patent office, it's considered to be what's called a social contract. So your patent document reveals to the world what your invention is, your innovation, and the patent document must be such that anybody else can then use that document to recreate your innovation. So if I see your patent specification, it's called, if I see it, I must be able to reproduce what you've created. And so that specification stays on the register, and once your patent has lapsed after your 20 years is up, then anybody can use that invention. So if you want to go and use old technology that's no longer protected by patent, you can use lapsed patents. It's up to 20 years because you have to pay government fees every few years to keep it active. Innovation patent is very popular because it's easier to get and it's cheaper. but the Australian government is considering doing away with it. Your patent protection can be locally for Australia, and you can extend it overseas to other countries. There's an international patent registration system called the Patent Cooperation Treaty. So that's in a nutshell, that is patents. Now, these days with startups, people are saying run hard, run fast, innovate quicker than your competitors. You don't really need a patent to protect you. I do take issue with that because there's a level at which you get to when you innovate that people aren't really going to improve on. So, for example, Cambrook is said to have created the plugboard that you see there on your screen, and they did not patent it because when the chap invented it, he thought that it was so obvious and so simple that any other electrician would have come up with it, and he didn't think it was worth anything. So if he had patented it, they would have had 20 years monopoly when nobody else could have used the plugboard. And now remember, the patent protects you for the way something works, not the way something looks. So being able to put multiple plugs in, 3 or more multiple plugs or 4 or more multiple plugs. It doesn't matter how people configured it, they would have been able to stop other people from using that invention in the countries that they had it registered in. And so the plugboard now has become a billion-dollar industry. So this is an example of where I think that sometimes people go wrong. They say, well, we'll just innovate quicker than anybody else. Sometimes it doesn't actually work that way. And also, if you are the first person to invent something, you can often charge a premium. So that's an example of a business that failed to patent something and then later regretted it. Now we're moving on to the second type of intellectual property, and this is a registered design. Those are teapots that look like toasters. So a registered design it protects the way that something looks. So it's the shape, they call it the shape or configuration. Very often people would want to register designs for things like furniture, new car parts if it's a particular new shape, jewelry. So if you're a creative person and you're creating new looking products, designs might be something for you to think about. The design has to be new when you file it, so you can't use it anywhere, you can't show it, you can't sell it, you can't give it away before you register it. Well, there is a slight exception to that, and with the patents as well, is where you have a non-disclosure agreement in place, which is basically where you've shown it to somebody and they've agreed not to disclose it. But generally, you need to file the design application first. Design also is per country, and in Australia it's valid for 10 years or up to 10 years. Other countries have different time periods, so New Zealand is up to 15 years. And in those 10 years or 15 years, you have the monopoly in that particular shape. In our own business, we've done a lot with designs with parts of trampolines. Surprisingly, there's particular shapes that are beneficial. And also things like jewelry. So furniture is also popular for registration of design. Design is fairly straightforward to register and is much cheaper than a patent. But if you have an innovation and you speak to a patent attorney, they'll be able to tell you which type of IP is better suited to your innovation or your design. So the design protects the way it looks, the patent protects the way it works. And so this was just an example that I had in our own practice. Jewelry designer designed a beautiful, unique ring, and then somebody else went and mass-produced her design afterwards, and there wasn't anything she could do because she hadn't registered that as a design. After that, she has decided to register her designs, which will mean people can't rip them off in the future. Now, this slide I have in here, as I said before, freedom to operate is not a type of intellectual property, but it's important when you're thinking about intellectual property. And what it is, it's a search to make sure that you avoid infringing intellectual property. We usually talk about freedom to operate as a search in relation to designs and patents, but it can also relate to trademarks. And if you are selling products or importing products, it's quite important to have a freedom to operate search, just to see what else is out there and make sure that by doing what you're doing, you're not infringing somebody else's intellectual property. If we do a freedom to operate search early on in a design process, it helps us because we can get the designer to what we call design around the already registered design or patent. So our client that manufactures trampolines, very often we'll say to them, we found this particular design or this particular patent. Your new design needs to be different so that you don't infringe. And the benefit of that, of course, is that they don't waste their time designing something that's in the end just going to infringe anyway. It is important to note that with patents and designs, when you have registered your design, it does not protect you. It doesn't give you protection against patent or design infringement. If you've got a registered trademark, that's a defense to trademark infringement. But with patents and designs, it's not a defense. So that's something that you need to talk to your patent attorney about. So just an example about a client of ours who they were an importer of small goods, and they received a letter of demand from Apple Inc., the people who make iPods and iPads, and it was 5 o'clock on a Friday afternoon, and they nearly had a heart attack when they got this letter of demand. What had happened is our client had seen Coles and Woolies selling chargers that were compatible with Apple products, and our client imported what they considered to be the same kind of chargers to charge up these iPods and iPads. And so our client received this letter of demand, which could have potentially bankrupted them. It was potentially for millions of dollars. And the Apple alleged that our client was infringing patents, registered designs, and trademarks. And so for them, if we hadn't been able to resolve the situation, that would have been the end of their business, a complete showstopper. So luckily we were able to negotiate with Apple. We agreed on behalf of our client that they wouldn't import any more of these goods. We didn't admit whether or not there was infringement, but then our client became an authorized Apple distributor. But the lesson from that is, just because you see somebody else doing something, it doesn't mean that you can do the same thing. And our client asked us, how come Woolies is selling something so similar to what we were selling and they're not in trouble? And my answer was, well, we don't know if they're not in trouble, and we don't know if they've got special permission from Apple. So don't take your cue from what's happening in the marketplace. It's more important to find out what is actually registered as a patent or a design or a trademark. And this was another example. We had a client who they started a new business and they developed a new car braking system, you know, to make it safer to brake in the event of an accident. Right at the beginning of the process, we had spoken to them about a freedom to operate search, and the client said, no, he's an expert, he knows all about cars, he understands what's in the market. And we explained to him, look, something might be patented but not yet in the market, so you can't see what people are already using in the market and take that as your indicator as to whether or not a patent is already out there. Anyway, he refused to do a search early on. He spent 18 months in research and development, hundreds of thousands of dollars, and he got investors in, and he was close to launch. When he was close to launch, he said to us, okay, now I'm ready, do the search. And unfortunately for him, his new invention that he had, or innovation that he had come up with, exactly duplicated an existing patent. So what that meant is that what he had spent 18 months creating, somebody else had already created and patented. So our client could not use that innovation. Well, they could, but they would be infringing somebody's existing patent. The owner of the patent was one that liked to enforce their rights, and so we had to advise them, not to go ahead and use that research he'd spent 18 months developing. So that was a bit of a sad example. And so this is the note that I mentioned earlier. Having a patent or registered design does not mean you can make or sell the item. Now, patent is usually for an item, but it can also be for what they call a method of manufacture, a way of making or creating items. So, for example, if you have a patent for a medical invention, you're going to need extra approvals before you sell whatever it is, your new drug. And if you're selling something and you've got a patent, you might infringe a prior registered patent or a prior registered design. Now, there are ways around that, and you can sometimes negotiate a license deal, so you can still use what you've created, but you pay a license fee. And in the example of our client who manufactured the car braking system, we had recommended that to him, but by the time he found out that he had duplicated what somebody else had done, he decided he didn't want to go ahead anymore. So having a patent or a design registration gives you the right to stop others from using and exploiting your invention. And now we turn to trademarks. This is our third type of intellectual property. So we've discussed patents, which is how something works, designs, how something looks, and a trademark or brand is, well, the brand and the packaging. Now, the brand could be a name like McDonald's, it could be packaging, it could be the logo. Sounds, shapes, smells can also be registered as trademarks. Catchphrases can also be registered. It is very important to understand and remember that your business name that you will have registered for your small business does not give you trademark protection. There are two completely different things, and this is one of the most common mistakes that business owners make. They register their business name and they think they're safe, they think they're entitled to use it. That's not the case. If somebody else gets your business name and registers it as a trademark, they can stop you from using your own business name. And I'll give you an example in a minute. So when you register a trademark, it's valid for 10 years and you renew it every 10 years. So this is different to patents. Patents, the maximum is 20 years. Here with trademarks, some trademarks have been on the register for hundreds of years. Once you have your trademark registered, it's a complete defense if somebody else accuses you of infringing their trademark. The trademark is registered for Australia, but you can extend it to other countries, and you have to nominate which countries you want. Also, when you file the trademark application, you need to specify what goods and services you want to cover with that trademark. So, for example, Cadbury's would be covering chocolate and confectionery type of goods. They wouldn't have protection for motor vehicles, for example. So when you protect your trademark by way of registration, it's important to know exactly what you're wanting it to cover. Now, I was at a workshop recently where somebody asked me a question and they said, if I'm using a name, isn't that automatically my trademark? And in a way, he was half correct, because once you start using a name, you do have some rights to the name, but if somebody else registers it first as a trademark before you do, then they get stronger rights. So he was sort of on the right track. The most important thing is the first person to file the trademark application has got the stronger rights in the business name or the brand name. And this is a real life example. My client was on Facebook. She struck up a bit of a friendship with somebody on Facebook, offered the person a job. This person who she offered the job to saw my client's business name, really liked it. It was unique. My client had invented the name. It was a made-up word. So the stranger registered my client's business name as a trademark and then sent her a lawyer's letter demanding that my client stop using their own business name. So you see what's happened. My client's got a business name. She thinks that's all she needs to protect her brand. somebody else has taken my client's business name and registered it as a trademark and then demanded that my client stop using basically her own business name. And so I had to explain to my client that once somebody has a name registered as a trademark, they have the stronger rights. So even though my client had the business name first, the trademark is the stronger right, and that trumps the business name. And so we had to discuss these options. My client could keep going and get sued because she was actually infringing a registered trademark. She could fight in court to get the name back, so get the trademark removed by this imposter. And my estimate was it was going to cost at least $200,000 in legal fees to do that. I was confident that we would win that case because my client had started using it first. But to be honest, she's a small business owner. She didn't have $200,000 to throw away to fight over the name. And then the option that she chose in the end was the rebranding option. It cost her $25,000 to rebrand her vehicles, her website, her stationery. She kept the same logo, but it was the name she had to change. She had to change her URL, so her web traffic all went to this name thief because they had the trademark. And my client had to just completely change her domain name. And then it cost her an additional roughly $10,000 in legal fees because we had to make sure that the agreement with her stopping using her name was going to be the end of the story, and the name thief, or the troll as I like to call him, we had to make sure that the trademark troll didn't come after our client for any profits she had made previously under that name. So you can see it was a complete disaster, and this disaster could have been avoided if she had got her trademark registered in the first place. And, you know, for, I think our current charges are $1,300, she would have had her trademark registered for 10 years. That includes government fees. It would have been a much better option than what she was stuck with. So when we negotiated the settlement, what we negotiated was she had enough time to register a new trademark before she changed her business name, so she only had to change it once. So she ended up changing her business name and her website and all her branding other than her logo, which was uniquely hers. And this happens frequently, where somebody registers the name that is your business name. There's some people don't realize that there are actually people out there which I call them trademark trolls. Their business, the way that they get an income in their business, is that they look to see what businesses are out there. Maybe you are raising your profile on social media. Maybe you've got a few speaking gigs. Maybe you're selling your business. Somehow they become aware of your business. And what they do is they search the trademarks registered to see whether or not you've got a trademark registered. And if you don't, then they register your business name in their own, your trademark, or your business name as a trademark in their own name. So they basically secure the trademark for your business name. And then they do what happened to my clients. They either force you to stop using that name, or they want to sell it back to you for tens of thousands of dollars, or they threaten to sue you for the profits you've made while they've got the trademark registered. So sometimes it happens inadvertently and people come up with the same names, but there are actually people who make a living by registering trademarks out from under you. So if you take nothing else away from today and you don't have your trademark registered, your business name registered as a trademark, that's something to put at the very top of your to-do list. Now, in the example I told you about before with my client, it wasn't a trademark troll. It wasn't the person who makes a living out of these things that went after my client. It was a person she offered a job to who, in the end, ended up being a competitor. So she didn't know this other person was going to start a small business. Now, it does sometimes happen that you inadvertently infringe somebody's trademark. And I had a client who has agreed for me to share the story with you. She invented the slogan, "Be the star that you are," which I thought was fantastic. She's a stylist. She helps people work out which colors are best for them and which styles suit them. And I heard her talk one day, and she was talking about "Be the star that you are" in relation, as a trademark in relation to her services. She helps you to be the star that you are. So I immediately said to her, "Oh, this is a great slogan. We need to register it." And then I did a search for her and found out actually somebody else already had it registered as a trademark. It was a massive shock to her because she thought she had invented it, but because somebody else already had it and they had it registered for styling services, my advice to her was that she had to stop using it, which she did very quickly. But if we hadn't done that search, we did it just before we were going to file the application for her to secure the name for herself. If we hadn't done that search, she could have been infringing that trademark for years and years and years, and then been sued for trademark infringement and potentially had to pay over her profits that she had made under that trademark. So she was very sad when we told her the trademark search results, on the one hand, because she lost her lovely slogan. On the other hand, she was really happy because she knew that she could get a new slogan, get it protected by trademark first, and then start using it. Now, with trademark searches, they can be a bit tricky. So there's an online database that's called the Trademark Register, and sometimes people like to do their own searches, but it can be tricky. And I've had a lot of clients report to me that they've had problems when they've done a search and then they've found no relevant trademark. So, for example, in that previous example, if you wanted to register "Be the Star That You Are," you would go onto the Trademarks Register and search for that name, that phrase. The problem is that when you search for that phrase, you're probably going to get thousands and thousands of hits because you can't actually search for a phrase. You can search for different words. So she might search for star or "be" and "star" or whatever. And so they get so many hits when they search that often people can't make head or tail of it. And one thing to remember about intellectual property and law in general, sometimes what makes logical sense doesn't make legal sense. So I had a client who his trademark was Miss, MIS, and he did a search and he didn't find any other trademarks on the register called MIS. He did find a radio station had been using the name MISS, Miss with two S's, and my client thought, well, that's different from what I'm doing. I'm a business consultant and they're a radio station, so firstly the words are different because mine's got one S, they've got two S's, and secondly they're a radio station and I'm a business consultant. But what he didn't realize was his trademark was so similar to theirs that for legal purposes they considered to be the same, because they sound the same and they look so similar and they've got a similar idea behind them. And also he didn't realize that you have to look at what the earlier trademark is registered for, not what they've actually used it on. And it was registered for goods including business consultancy services. So even though they were a radio station, they had it registered for business consultancy services. So trademark searches can be tricky, and the results that you find aren't always logical, or the way that the results would be applied aren't always logical. So he was very upset. He did the search and then filed his own trademark application, only to find not only could he not register the trademark he had selected, but he was in fact infringing a prior trademark registration. And expensive rebranding followed. Oh, I've got the wrong title up there. This was not self-search. This was an example of a client of ours where they received a letter of demand from a a large real estate agency, and the large real estate agency said to my client, I want you to change your URL and your business name because you're infringing our name. And so my client said to me he was happy to do that. He didn't mind changing his name. He didn't want to fight with a large real estate agency that had endless pots of money. And he came to me because he wanted to do it the right way. So I had said to my client, well, no, you don't have to change your name because you have got a trademark registered. And in fact, if anything, they're infringing your trademark because you've got yours registered. So we just sent a very simple letter to the large real estate agency and said, no, our client is not going to change his business name. And in fact, we want you not to use this name anymore. And they completely backed off. And so that's the power of having the trademark registered. My client had the trademark registered. Somebody tried to fight with him over it. All we did was we sent them his trademark certificate and they completely backed off. So that was a happy ending and he was very pleased. Now, for trademark protection, there is an option to file trademarks yourself, but I do just want to point out to you that there can be some difficulties with doing it that way rather than through a professional. If you're going to get a professional to do it, I do recommend that you find out how many trademarks they've actually filed. Sometimes general lawyers will say, yes, we'll do your trademark for you, but maybe they've only ever filed 2 or 3 and it's not their main thing. So if you're going to get a specialist to do it, obviously you want somebody with experience in trademark filings and also in trademark disputes because they will know more the kind of things to look out for. And it was interesting, I recently did a do-it-yourself trademark workshop and the attendees there, 50% had previously self-filed their trademark and 100% of those had made significant mistakes when filing their trademarks. And interestingly, the most common mistake they made was when you file a trademark, you can file it in 1 or more of 45 different classes, and they had filed it in classes they didn't need it. And what happens then is per class, you have to pay an extra government fee. So out of those people at the workshop, one lady had wasted $2,000 on unnecessary government fees when she previously self-filed, and then another one had got completely the wrong protection. It didn't cover her for what she was doing. She's doing blogs and video podcasts and that kind of thing. Or no, she's actually a business consultant, and then she ended up with telecommunications protection, which, you know, Telstra would be filing trademark protection in the telecommunications class. So she was a business coach, but again ended up wasting her money. So if you're getting trademark protection, some people do self-file and they self-file successfully, but you do need to make sure that you're getting the right protection. And if you're getting professional help, think about getting somebody who has got a lot of trademark experience. So now we move on to the 4th type of intellectual property that I wanted to talk to you about, and this is copyright. And this is the one, trademarks and copyright are the ones that generally the most important for small businesses. Copyright is literally the right to prevent others from copying, modifying, or displaying your works. Now, your work could be a blog that you've created, it could be any written material, it could be photographs, it could be pretty much anything that's written, diagrams, logos. And for something to attract copyright, it needs to be what's called original. So somebody needs to have created it. It can't itself be a copy, and it has to fall into a specified category, such as a literary work or a written work or a artistic work. So every business throughout their day-to-day work is creating copyright works. So when you create a procedure manual so that people know how to follow the process in your business, you're creating a copyright work. When you create a slideshow presentation like this one, the actual slides themselves are copyright works. When you take photographs for your business or personal use, again, you're creating copyright works. So copyright is very powerful. Copyright automatically exists. You don't have to register it anywhere. And in fact, you can't register copyright in Australia. The only place in the world where you can register is in the USA, but you don't have to register it. So copyright exists automatically, and this is another important tip for small businesses that they sometimes don't know about. When you're creating whatever it is you create in your business, reports or written documents, it's useful to keep accurate dated records of drafts of reports and things, especially if it's going to be something that other people might want to replicate and use. Because if you've got dated records, then you can prove you own the copyright in that, whatever the item is. Copyright, another important point about copyright is to be aware to avoid copyright infringement either yourself or by your staff. So the best way to avoid copyright infringement is to create your written work and your diagrams and your photographs yourself. That's a good way to avoid copyright infringement. One way to avoid copyright disputes is to always record in writing who's going to own the copyright. I have this a lot where clients have somebody create a logo for them, and then there's a dispute later on as to who owns copyright in the logo. So sometimes a designer's terms and conditions will say, well, I own the copyright, but the client who paid for the logo expected to own the copyright themselves. And then when you produce written work, I recommend that you use the copyright marking. So when you use your keyboard, if you do the bracket C bracket, it will actually form the little circle with the C in the middle. And then you put the date and the name of the person who owns it. If you've created it over several years, always put the earliest date and then the dash and the most recent date. So you can see at the bottom of my slide there, I've got copyright 2007-2016. The early date is the most important one, because if I only had 2016 and somebody else disputed that I owned this copyright in the slide, and they created it maybe in 2014, they would prevail. So the earlier date is really important to mark on anything that you create that attracts copyright. So this is what I was talking about a few minutes ago. It happens so often where somebody asks a designer to design a logo for them, the client files for the trademark, they want to protect the logo as a trademark, and then they discover the logo is actually a copy of a trademark that's already registered. And then the poor client who's been using the logo gets threatened with trademark infringement for using a similar logo. So when you instruct a designer, it pays to always say to them that you want in writing that what they're creating is not going to be a copy of anybody else's material. Right. We're not doing a poll, but I just wanted to do a hands up, a quick hands up. Who uses free image websites? What I'm talking about is free images to put on your blogs, free images to put on Facebook, free images just by hands up. It could be just Googling images. It could be different types of free image websites like Pixabay. I'll just give you a look. And if you can type in the comments which free image websites you like best.
Perhaps if you type those into the questions panel.
Yes, please. Are we getting hands up, Leanne? I can't see.
Yes, we have, I would say, about half of the people. Just looking at this, yes, we certainly have plenty of people who have got their hands up.
Fantastic. Right. Listen up. This is for you. Very, very important. So even if you don't use free image websites, this is important. This is a screenshot of Pixabay. Pixabay is they call themselves a free image website. This is just one example. Every other one that I've examined is very similar. It talks about free high quality images, free videos. You can use them anywhere. You can use them for any commercial purpose, and it even says it's use under Creative Commons. The problem is that this is not true. If you scroll down to the very bottom of Pixabay's page, you'll find terms and conditions, and this is in every single free image website. You scroll down to terms and conditions, and what they say is that they do not bear any responsibility for copyright ownership of any of the images shown on their site. So if you are using free images from whatever source, other than something like Canva, where they've got free images and paid images, that's different. But a free image site, I have not seen one that truly is free image site. And I'll give you a quick example. This is my lovely client, Elaine. She runs a hypnotherapy clinic. She got somebody to create her website for her. The designer got some free images off one of the free image sites, and she got a letter of demand from Getty Images, is the main owner of images. This is not her letter of demand, but it's an example of what it looks like. So if you use those free image websites, you're at severe risk of getting one of these letters of demands. The reason for that is that the site, like Pixabay, takes no responsibility for what images are placed onto their site. So, for example, I could go and get an image of Getty Images site, and I could put it on Pixabay and pretend that it's a free image. And Pixabay steps back and they take no responsibility whatsoever. So every time you use a free image, the true cost is probably closer to this, $1,300. And in fact now, in recent months, I haven't seen any letters of demand less than $1,500 per image. So my lovely Elaine, who's the hypnotherapist, she ended up having to pay Getty Images because her designer did not have a license agreement that she could show Getty Images that she was authorized to use the images on her site. So I don't like to scare people, but there are cheap image sites, and I can send the link afterwards. Leanne can send that around, where you pay $99 for 200 images, which you can use over a year. It's much, much cheaper than having to pay this kind of money. So here's Canva. This is an example of, they do have some free images, but they also have paid images. So you're using the images within their website, so you know that it's safe. And then Wikimedia Commons, this is one of the exceptions where this really is under the Creative Commons license. You really can use their images for free. And the reason why you can trust this one is they require the owner of the copyright to upload the image. So when you upload an image, you have to say, I own copyright in this image, so that gives them some quality control. And that's, with Pixabay, they don't have that. Anybody can upload any image. The other thing with Wikimedia Commons or similar Creative Commons licensing systems, mostly you have to acknowledge the owner of the copyright. So I don't know what that image is, but if I wanted to use that on a blog, I would have to say the photographer was whoever, whatever their name is. And usually when people are using images on their websites and their blogs, they're not acknowledging ownership or copyright ownership. So for me, going and paying for your images or getting a photographer to do your images is much safer. Please do not put your head in the sand about this. So many people have had problems with Getty Images. And you can be liable for infringement if your web designer takes an image off the internet, if it's your graphic designer, staff, or contracts. So I really recommend that you have an image policy. Now, Leanne, I see that we're only with 5 minutes to go. Should we do some questions?
Yes, I think, perhaps we could move to questions. I know you don't have a lot of slides left, but certainly let's shift to some questions. And just I'll take this opportunity to let people know I'm about to send not some URLs, but certainly some names of some companies where you can purchase stock shots and subscribe for certain limits or unlimited stock images.
Okay, and just it's important to make sure that you understand what the limits of the licenses are, because I had a lady the other day who's a graphic designer, and her license allowed her to use the images herself on her own website, but not on her clients' websites, and she didn't realize that. Do we have questions, Leanne?
We certainly do, and Clinton has some questions that relate to having trouble attempting to sell a design or invention to a potential buyer and being asked to sign an NDA. And, he just wonders, how perhaps he should have approached that.
I can't see the actual question.
Yeah, no, it's a bit convoluted, it's a bit further down, but basically Clinton's asking about NDAs.
So an NDA, Clinton, thanks for your question. You would normally sign an NDA before you reveal confidential information. If you already have a registered design in place, there's no need to sign an NDA. But if you're going to show somebody your design that has not yet registered, then you should get them to sign the NDA before you reveal your design. So I'm not sure if that answered your question. If not, you can drop me an email. But generally, NDAs are for information that's not yet made public. We've got another one there?
Yes, Cathryn. Lisa would just like to confirm that a service-based business still needs to trademark the business name.
Yes, absolutely, Lisa. In the old days, you could only get a trademark for goods. Now you can get it for goods and services. So, for example, if you write electronic books, for example, you could get it registered in Class 9, which is electronic media, books and things like that, apps. But you can also get it in one of the service classes for whatever your services are. And if somebody else, it's the same story. If somebody else gets your trademark registered before you do, the problem is they can stop you from using your business name. So absolutely.
Thanks, Cathryn. And along those lines, Christina is asking about trademarking the name of the business as well as the logo. Are the business name and the logo two separate trademarks?
That's a fantastic question, Christina. And it really does depend on how descriptive your business name is. Generally, you would file the business name words only as a trademark and then the logo separately. And the reason for that is it gives you a stronger protection, because if you register them together, you get only the protection for the combination, not for the words on their own and the logo on its own. If you've got a business name that's a bit descriptive, so we had a client had My Career Employment Agency, and I said that was too descriptive. You're never going to be able to monopolize that as a trademark. So he filed that together, the words together with their logo, and we got that through. So your trademark has to be distinctive. It can't be descriptive. The other reason why I say always go, if your finances only allow you to file one, then do the words only, provided it's not too descriptive, because you should have copyright automatically in your logo anyway.
Thanks, Cathryn. This is sort of going on a different tack from trademarking. When recruiting employees, should you arrange for them to sign non-disclosure for sensitive business info? Or what are some other ways that you can secure your business from employees taking that information when they leave?
Yeah, that's a good question, and I spoke too long on patents and trademarks. It was going to be one of my other topics I was going to talk about. And yes, trade secrets are the other way. There it is. Trade secrets are the other way of protecting information. So whether it's employees coming in or you're dealing with somebody who's going to finance your business, it's good to have a non-disclosure agreement in place because it keeps your information, or it gives them the obligation to keep your information secret. Without an agreement, they can do whatever they want with your information. So I've had a client who they went to a large government organization and provided the government organization with useful business information, and my client was going to go in and set up a system for the government department. There was no NDA, and the government department then decided to use my client's information and set up their own system in-house. And because my client didn't have an NDA, they couldn't stop them. So anytime you're giving away or you're revealing sensitive information, yes, absolutely, NDA is the best way to go.
Thanks, Cathryn. And here's a different type of question again that hasn't been covered yet in your presentation. How does one go about protecting practical application of Indigenous knowledge?
That's again is a little bit tricky. If the practical application is something new, then you can proceed by way of patent. If it's something that's traditional knowledge that's obviously been around for generations, in Australia there is no way to protect that. In New Zealand they were, they are in the process, and in some other countries as well, they are in the process of trying to get together a system to protect that kind of knowledge. But unfortunately in Australia we don't have that. So if you've created something tangible like a new workbook or something like that, you would have copyright in that, but the underlying Indigenous knowledge, unfortunately at the moment we rely on people's moral codes not to monopolise or commercialise inappropriately.
Thanks, Cathryn. Another question here on an area that you weren't able to cover in the short space that we had today is relating to plant breeders' rights. How unique does a new plant variety need to be from an existing trademarked variety?
Oh, they're completely different things. Yeah, I might need to answer that one personally. I can't answer that one I can't answer that one on the fly. Yeah. Sorry.
Look,
I have to be honest, I have not done many plant breeders' rights, so it would be useful if I had the two to compare, and then I'd be able to answer the question. But in theory, I can't answer that one. Sorry.
Yeah, Derek, if you have downloaded the copy of the slides, you'll find Cathryn's contact details in them, and Derek, you could perhaps give Cathryn a call or send her an email, and she may be able to provide you with some direction for answering that question.
Yeah, my email's on the last slide, Derek, and my business partner actually would be the one I would direct that question to.
Yeah, we have gone over time. We're 5 minutes over, and people are starting to leave the webinar because they have other appointments.
Certainly.
So I think that what we'll do is that we might end things here, and certainly if people have further questions, they know where to find you, and also the IP Australia website has a lot of resources to help as well. Cathryn, any final words before we leave for today?
Yeah, just thank you very much, everybody, for your time and attention. Please do send through your questions by email, and I do have some free ebooks if anybody is interested. Sorry, I didn't get to it. I've got an ebook called IP Killers for small business, and then if you've got specific questions, I see there was a question about business structures. I've got free ebooks on those, so if you send through your questions, I'll either answer them personally or send you a free ebook if I've got one that covers your topic.
Yes, no, you've just prompted me to your handbook for small businesses, Lawyer in Your Corner, I believe that's what it's called.
That's
Yes,
right.
that's a great handbook, for, particularly for small businesses. But you'll find all that information on the Acacia Law website. Thank you very much, everybody, for tuning in today. We look forward to your company, perhaps at some other webinars that we're running this week. You can tune in tomorrow. We're looking at crowdfunding with John Matthew, who's just finished submitting his PhD on that subject. Thanks again, everybody, and we look forward to your company again at the next webinar. Bye for now.
Thank you.